At 9, it's an all-new Forensic Files, and at 10, it's a premiere episode of Psychic Detectives on Court TV. It's seriously entertaining.
There is still time to get your thoughts into both sides at courttv.com and answer our email question of the day. What rights should be given to accused criminals? Send us your answer. It just might end up being our choice for email of the day. And joining us now to help analyze this case live from outside the Sarasota, Florida courthouse is local criminal defense attorney and former prosecutor Varinia Van Ness. A pleasure to have you with us again.
Thank you. It's nice to be here, and thank you for having me on your show again.
Our pleasure. So polite. All right, so you were in court today, and you were able to take a look at what happened. Sum it up for us. What did you think?
Well, the defense is really trying to do something. This case is so strong for the prosecution. They've been trying to bring people that have been at the scene, people that were spotted at the place where Carly's body was found. There was a worker of the grounds for the church. What time was he there? There was also an individual that was spotted by a trooper not far from where the body was located. And the defense is trying to portray as if these people had access to this area, that maybe the information came from someone other than Joe Smith, and they should have been suspects that the law enforcement should have looked into more detail and carefully, and they didn't. So they're trying to point the finger at someone else.
Varinia, Vinny Politan here. Welcome back to the show. I guess I wasn't here the first time you were on, but great to see you anyway. If you were trying this case, if you were defending this man, Joseph Smith, would you be concerned in trying to point the finger elsewhere when there's so much overwhelming evidence that it is in fact Joseph Smith, that you might lose some credibility with these jurors when it's time for the penalty phase, if we get to a penalty phase?
Absolutely, and the last time I was on the show, I addressed that exact issue when we were talking about the gruesomeness of the photographs, and there's just such a big mountain of evidence that you really do lose credibility with the juries. Like even if you have something viable to present, they might be like, what are you talking about? This other garbage that you're giving us. So I really have to question Mr. Smith's decision of going to trial rather than entering a plea and just focusing on the penalty phase, because it's going to be the same jury who's going to say you get to live or you get to die, and now they know every little detail of the case and what and everything that the prosecution presented. So that's going to be a real big hurdle, and I just question that decision.
You know, it's interesting you say you question it, because is it true though that the public defender's office there won't plead somebody out in a guilt, to the charge, won't do a no contest plea in a capital case, in a death penalty case? I mean, is that just their policy? Do you know what I'm saying? So they said, no, we're going to go through a jury trial on this and sort of take our lumps with it. I agree with you. When Vinny and I talked about this the other day, we kind of felt like he should have just entered a no contest plea.
Well, I'd question the public defender having a policy, and I don't know because I've never worked at that office, but the decision that's made is not made by the attorney. It's not made by an office as a general policy. The decision whether or not you go to trial is made by the accused.
Right.
For example, in the Danny Rollins case, you know, he had 5 murder charges of mutilation, and he entered a plea and just went through the penalty phase. So I really don't know that is true.
Yeah,
if
I don't think it's a good decision.
I'd be very concerned.
Wait, so Robert Little, you want to weigh in on the other side of that?
I disagree with all of you. I think you go to trial. I don't think they're doing it right in this case, but I think you go to trial and use opportunities as the trial progresses to make points toward mitigation. Now, this isn't what they're doing, and they're messing it up by trying to say there's a Plan B defense and somebody else did it.
Well, what would you do?
But don't give up your opportunity for advocacy. Instead, don't cross-examine most of the witnesses, but when the opportunity arises to lay some groundwork and plant some seeds in the minds of the jury for mitigation, you can then pick up on that in the guilt and the death penalty phase and say, look, we never promised you that he was not guilty. We never tried to trick you. But we wanted you to pay attention to a few things, and now we're going to expand upon that.
All right. Well, it sounds like a strategy, Vinny, but I mean, how do you do it really in this case? Because what do you have to work with? I think you'd have more credibility if you just said, okay, look, I'm accepting responsibility. I did a horrible thing. This is how I ended up in that circumstance. This is why it was so out of character. This is why I'm terribly sorry and remorseful and wish I was dead, but I beg you, let me suffer and spend the rest of my life behind bars.
Yeah, you know, the thing we hear from jurors a lot of times in death penalty cases afterwards when they speak is, you know, I didn't see any remorse.
All
from
the time
defendant.
they say it, yeah.
And if you show that, maybe you have a better shot to save your life. But the question is, you know, a criminal defendant, it's tough to put yourself in those shoes because you never want to be in those shoes. But here you are, you know, they've got to prove the case against you. Do you just want to, you know, lay your cards out and say, all right, I did it?
They got him dead to rights, though. I mean, in this
the
case,
problem is there's too much.
Too much.
Varinia, have you ever seen a case where there's a videotape, an audio tape, a fingerprint, a confession, taped phone calls, DNA? I mean, I've never seen a case that has everything, because every time we turn around, it's like, well, they don't have this. Oh, they do have this. They do have this. They do have this. They have every type of evidence you could have. They seem to have in this case.
And they have DNA, they have confession, they have deciphered, they have everything. And that's why I think that all the mitigation that you want to bring out, you can do that during the penalty phase, and the jury doesn't have to be thinking, why are you putting us through this? Why do we have to spend 3 weeks listening to all this? Give us the mitigation, but don't make us go through the guilt phase. That doesn't make any sense to me, and I would seriously counsel my client. The client doesn't go to trial and find out what the evidence is against them during the trial. In Florida, we have discovery, and the defendant gets to see every piece of evidence that the state is going to have, so he's not going to be surprised that, ooh, they deciphered my note, and oh, they have semen or whatever on the shirt. So this is not a surprise. He knows what was going to be presented, so it's not something that you decide midway through trial, oh, they got me.
Yeah, Robert Little, and the videotape, News at 11, anyone? I mean, he knew about that too. I mean, come on.
Yeah,
are you sure you don't want to rethink that whole idea of not having
absolutely not. You know, I think I tried this case once. I had a guy who was caught red-handed and on a videotape and gave a confession and the whole thing. Fortunately, it wasn't a death penalty case. But I still think it doesn't have to be 3 weeks if it were done properly, but choose some opportunities to lay some seeds for mitigation, and don't just say, but for the vast majority of the witnesses, you'd say, look, we have no contention with what he said. We'll stipulate that his DNA was found here, for example. But start to explore this idea, which I think is going to be their mitigation. And what he said to his mother and brother was, well, I was on cocaine at the time. Now, I'm not telling you that this is a great mitigation, but it's what you have.
Right.
But lay the seeds and say, look, you know, he did something wrong. We're not saying he didn't do it, but to just plead straight up, as we say, and go to the guilt phase, you're missing a whole opportunity.
Robert, it was so brutal, okay, in that courtroom with the evidence. I'm sorry. I mean, the jury there taking a look and listening over and over again to the description of her little 11-year-old naked body with her little bra pushed up and her top, no panties on, no pants on, the animals and the insects, the bugs eating away at her body. No way. I mean, there's no way. That jury is probably so disgusted they can't wait to get to the penalty phase.
I suspect that's probably
disgusting. You know, it really is. It's really gross. And I mean, if I was his defense attorney, I'd say, hey, buddy, you're sick. You've got issues. You're in big trouble. Take a look at this. Get a grip. And do your little duck foot walk straight into the penalty phase and throw yourself on the ground in front of this jury and beg for them to spare your life.
Well, hopefully they've had that conversation. On the other hand, what he can do is say is blame all that on the state and say, look, we've stipulated all that, but they still want to bring out all this gruesome testimony. So it's their fault they're putting it on and not our fault.
All right, yeah. Cooked duck for Joseph Smith. Cooked duck. All right, after days of damaging testimony presented by the state, including videotape, DNA, and audio tape evidence, the defense began its case today. Will Joseph Smith's attorneys save their client from a possible death sentence? Live testimony is going to resume shortly in the courtroom, but first, we're going to check in with Len Cannon. He's in the Court TV News Center, and he has an update for us on the rest of the day's legal news.
Hello, I'm Len Cannon with the latest from the Court TV News Center. Another day of jury deliberations are underway in the wrongful death trial of actor Robert Blake. Blake was acquitted during the criminal phase for the 2001 shooting death of wife Bonnie Lee Bakley. Now a jury must decide whether he is liable for the crime. Joining us now live from outside the Burbank courthouse is Court TV correspondent Gene Cassars. I know, Gene, it's been a long stretch for you. Any news?
Well, there's a very lively discussion going on in that deliberation room. Very loud. We're hearing noises, and actually, it was so loud at some points we were able to actually understand some sentences. We heard one person say, that is what I want to clarify to everybody. Talk, 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 talk. And then finally somebody says, okay, listen up, everybody, listen up. So those were the two sentences that we actually heard. They've been deliberating 20 and a half hours at this point. In the courtroom, you have Robert Blake, you have Earl Caldwell, co-defendant. You've got Nancy Lucas, defense attorney. Eric Dubin just arrived. You know, he's commuting from Irvine now, which is Orange County, and this is Los Angeles County. That's quite a hike. The plaintiffs, though, they have gone back to Tennessee. Do want to tell you, Len, that Robert Blake wrote some more poetry to me today. He apologizes. He says that his creative juices are not really flowing today. This is all he could come up with. What he said, he wrote, "The sparrow sings in winter because he believes in spring. Man can be destroyed, but he can only defeat himself." And, you know, if you read between those lines, that is the Robert Blake I see in the courtroom. If you think he's carefree in that courtroom, think again. He is stressed. He is very stressed because he is the main defendant in this case, and he doesn't know what the outcome is. Everybody is waiting, wondering what is going to happen, and only hoping that there is a verdict today. But as he has those stressful moments, I think writing poetry like this actually helps him, and I think these are the types of thoughts that he is thinking himself right now.
Gene, I think Robert Blake has taken a liking to you while we wait for the verdict in this case. Gene Cassar is reporting live from Burbank. Thank you, Gene. And stay tuned to Court TV. We will bring you the verdict as soon as it comes in. Cindy Sheehan, who made headlines protesting against the war near President Bush's Texas ranch, made an appearance in a D.C. court this morning. Sheehan, whose son died fighting the war in Iraq, was arrested in September for demonstrating in front of the White House without a permit. Sheehan and several other protesters could have just paid a $75 fine, but instead the group opted to have their day in court. A Tennessee judge has ordered the 14-year-old boy who allegedly shot 3 people at his high school to undergo a mental evaluation before they decide to charge him as an adult. Police say the teen shot his principal and 2 assistant principals last week after being called into the office. The principal had been tipped off that he brought a gun to school. One of those assistant principals died. The other 2 men are still in the hospital. In Miramar, Florida, a 17-year-old girl is facing attempted murder charges for allegedly shooting another student on a school bus. Police say Camille Burke shot Kalisha Cheatham in the chest while the 2 were on the way to school Tuesday. The incident appeared to be related to a previous altercation between the girls. Other students on the bus say Cheatham, who is now in guarded condition, allegedly punched Burke in a fight the day before. And that's the latest from the Court TV News Center. I'm Len Cannon. Both sides with Kimberly Guilfoyle Newsom and Benny Politan. Back after the break.
A guide to proper manwich etiquette. Always use the correct utensils. Sit up straight and don't fidget. And be sure to use a napkin. Eventually. When it comes to dinner, it's manwich rules.
Class of 95. Here I come.
Weekends look even better at 50% off. Rent Friday to Monday, 50% off. Pick Enterprise. We'll pick you up.
He's much heavier and his hair is different. It's longer and maybe in a different haircut. But he's quite a bit heavier than he was.
Defendants often undergo changes between being arrested and standing trial, but rarely does the defendant gain such a noticeable amount of weight as the defendant in today's case did, Joseph Smith. Welcome back to Both Sides. I'm Vinnie Politan along with Kimberly Guilfoyle Newsom. Now, we searched through the Court TV archives to find a defendant whose waistline had met a similar fate to Joseph Smith's. And some of you dedicated viewers may remember Sybil Paget. Paget stood trial for murdering the wife of her boss's former lover. Paget's lawyer said her client gained weight because of a high-carb diet in prison. A Michigan jury returned a guilty verdict for Paget, and she's now spending the rest of her life in a carb-ridden prison. Now, if Smith is convicted, will his weight gain continue during his prison